like to clarify.
I want to let you do that, but sometimes when people talk about the weakness of parties in the current day, what they mean is that parties have no control over individual candidates, senators, House members. So how would this affect that? If you thought that, and obviously we're not in the business of trying to figure out whether parties need help and how best to provide it, but I'm just wondering if you think that the real problem with the weakness of parties is that there's not enough party control over candidates, how does that play out?
Right. So I would answer that in two ways. The first, with respect to the actual plaintiffs below, the petitioners in this case. The membership of the NRSC is the sitting caucus of the Republican senators. The membership of the Congressional Committee are members of the Republican Conference. They are part of leadership. They literally are listed in the official directory. They are elected as part of the official election of leadership in the body. I promise you, that is where their power comes from. Their power comes from the fact that they are a coalition of incumbent members of the House and Senate. It is not because of their ability to paymaster more money to this candidate or that candidate that gives them power in their elections. Can I make just a couple of points? First, very small. Mr. Martinez asked if an advisory opinion binds private parties. It does. It acts as a complete shield against any liability, criminal, civil, by anyone. The second question was, there was a lot of discussion about super PACs and the relative power of super PACs versus the party committees. The key benefit that the party committees have that seems to have gone unmentioned is actually found in McConnell, which is the member of Congress can't solicit money for a super PAC in excess of $5,000. So when we talk about, oh, well, they would much rather have the money go to a super PAC, well, that may be what they privately want as an elected member of Congress or as a candidate. But candidates and office holders cannot solicit for these super PACs. So it's not just that they're independent in their spending, they're actually on their own, largely, with some exceptions, which I'm happy to address, in how that money is raised. With respect to the earmarking rules, there's been a lot of mention about the earmarking rules, but not a lot of discussion of it. The reason why the earmarking rules are not effective, and I think this is a bit of a change since McCutcheon, frankly, are for two reasons. The first is because joint fundraising is essentially an exception to the earmarking rules, right? Because after all, if you have a joint fundraising committee between a candidate and 50 state parties, the candidate's name is in the joint fundraising committee because they are a participant. So it's not illegal earmarking that someone is giving to the Trump Victory Fund or the Hillary Victory Fund or the Biden Victory Fund. It's required by the regulation because their committee is getting the first money in that arrangement. So I think that first of all, you have to understand that the earmarking prophylactic just doesn't have any application in the joint fundraising arena.